Welcome to another episode of The Dissection. Tomorrow is actually a very big day in South African criminal law and constitutional law. 26th of November is a day which is curious because on the same day, the president and the Phala Phala matter are going to the Constitutional Court. Well, not the president exactly, he's not going to physically necessarily go, but the EFF has taken the Phala Phala matter and the decision by Parliament to vote against going to the second stage of an impeachment process to the Constitutional Court. So that issue has been set down for Tuesday, the 26th of November. And on Tuesday, the 26th of November, the criminals who stole, or rather the accused persons who stole the money, the foreign currency from the furniture of President Cyril Ramaphosa, are actually going to be in court and their trial is going on. So earlier this year, the Limpopo Director of Prosecution said that they're not going to prosecute anybody in relation to the money. And this is in respect to the president, anybody who was in his personal security, anything that may have happened trying to get the money. They said, no, we're not going to prosecute anybody. But they have actually prosecuted the people who stole the money. So those who had the money, no prosecutions. Those who stole the money, how did you steal this money? That's a crime. So this split screen is happening tomorrow. The split screen is happening tomorrow. The media has not been speaking about this sufficiently. There's been a lot of discussion about the miners. There's been a lot of discussion about spaza shops. There's been a lot of discussion about Floyd Shivambu and other people joining the MK party. But you have not had the level of exposure or analysis or introspection around Phala Phala. It's been a few articles here and there considering that this is going to the Constitutional Court. When Zuma was going to the Constitutional Court, I saw a lot of analysis on media around the various issues around contempt of court, all of that. There was extensive analysis, extensive panels. When I looked at the coverage of Trump being charged in America, there was back-to-back coverage of that particular issue. And this particular issue seems as if the media is just going, they don't care as much. The explanation for why the media doesn't care as much comes in this book, Manufacturing Consent, by Edward S. Herman and Noam Chomsky, where they speak about the propaganda model of the media and how the media will select who gets attacked, who gets focused on, what they spend a lot of discourse time on, based on the interests of the owners of the media, the advertisers, the billionaires, and the audience which watches that particular media. So if they ascertain, for instance, on CNBC that, hey, these particular viewers don't want to hear why Trump is popular with the working class, they may not necessarily focus on news stories that give that information. They may just keep saying the election is close, the election is close. But when he wins, they'll say, oh, we always knew that Trump was popular with the working class for these reasons. So it hasn't been discussed enough, but somebody has contributed to the conversation in a big way. Nosiviwe Mapisa-Nqakula says she opened a can of worms with her inquiry into the Phala Phala saga, and this is when she was speaker. So Nosiviwe Mapisa-Nqakula, who is the former parliamentary speaker, said her legal challenges with the state began when she convened an inquiry into the Phala Phala matter. So her insinuations against President Ramaphosa appear on a recently filed court application to have the state disclose further details surrounding her ongoing corruption case. This is what she said. When I elected to convene a parliamentary inquiry into the Phala Phala matter, I made political enemies. When I made this choice, I did so without fear or favor and followed the rule of law. I opted for a public vote on matters concerning the sitting president, Mr. Cyril Ramaphosa. So that's what she said. And we have to go to the timeline and reflect, because this is actually a big story. You have to appreciate President Cyril Ramaphosa almost resigned as a result of this issue. Before the vote, he almost resigned, and then there's all kinds of conjecture and discourse around what happened behind the scenes to force him to stay. But here's what happens. We know that on the 1st of June or thereabouts, I think it was the 1st of June, Arthur Fraser went to the Sandton police station, opened the case on Phala Phala, accusing the president and other individuals of a variety of issues. So that is what set the ball in motion. Then a complaint was made to the Office of the Public Protector. But as it pertains to Parliament, on Tuesday, the 14th of June, the African Transformation Movement, which is a political party represented in Parliament, submitted a proposed motion to the Speaker requesting the House to initiate an inquiry into the removal of President Cyril Ramaphosa from the office of the President of the Republic of South Africa on specific charges. The Speaker, Nosiviwe Mapisa-Nqakula, initially declined the motion as it was not compliant with the applicable rules of the National Assembly. Following engagements with the members of the ATM party, as directed by Rule 129B, they discussed how to ensure compliance of the motion with the rules, and an amended version of the motion was subsequently submitted on the 18th of July in 2022. Right? So Rule 129C of the National Assembly requires that when a motion is in order, which is when it's in alignment with the rules, the Speaker must immediately refer it and any supporting documents to an independent panel of experts. And this is a motion around impeachment, right? In terms of the rules, the Speaker must appoint the panel after giving political parties represented in the Assembly a reasonable opportunity to put forward nominees, and after she has given due consideration to all persons so nominated. So this is what triggered this particular process. ATM was like, no, we need answers. And there was an appetite in the ANC at that particular point to at least start the process and make it clear that there's nothing to hide, there's nothing here. It's just a opportunistic attempt by Arthur Fraser to get the president back after he had been removed as the director of the correctional services. So this is what was happening at the time. On the 5th of August, Friday the 5th of August, the Speaker of the National Assembly considered the motion which was submitted in terms of Section 89 of the Constitution and Rule 129A to Q of the National Assembly rules as introduced by the African Transformation member, and this was done by Vuyo Zungula, by the way. She considered this to be compliant, and then the ball was set in motion. Right now you have to nominate all of those names. And on Wednesday, the 14th of September, 2022, the Speaker of the National Assembly said that she had looked at the 17 nominees which were recommended by the political parties represented in the National Assembly for appointment to the independent panel. And of the 17 people who were nominated, 11 were retired and serving judges, and 6 were advocates of the High Court, or they were senior counsel, or they were law academics. And the Speaker had spoken to the Chief Justice of the Republic of South Africa regarding the appointment of judges to the panel, and she had received concurrence, and this was discussed in a statement. And the appointed persons were the following people. Justice Sandile Ngcobo, who was the former Chief Justice of the Constitutional Court of South Africa, he was appointed as chairperson of the panel. Judge Thokozile Masipa, who was a former judge of the Gauteng Division of the High Court of South Africa, was appointed to the panel. Professor Richard Calland, a professor of public law at the University of Cape Town, was also appointed to the panel. So things were still okay. Then something happened, which I think this is, in my opinion, what got Mapisa-Nqakula into a little bit of trouble. I want to tell you what happened on the 27th of September, Tuesday the 27th of September. This is where something happened. On that day, the Speaker announced that she had changed the composition of the panel. Right? The Speaker had received objections from the Democratic Alliance, the Economic Freedom Fighters, and others regarding the presence of Professor Calland on the panel in and of itself on the basis of perceptions of bias and real or actual bias. And what she said is, having considered all the submissions from the political parties as well as the legal opinion from Parliament, the Speaker was of the view that there existed no factual basis to corroborate any perceived or apprehension of bias, but the integrity of the work of the panel would be best served if Professor Calland was excluded from the panel. She then appointed Advocate Mahlape Selo to replace Richard Calland. right? And Advocate Mahlapiselo is a respected senior counsel with decades of experience in the legal practice and served on the Judicial Commission of State Capture. So that decision removed somebody who was viewed as an ally of President Ramaphosa, somebody who was going to maybe protect him, right? On the 30th of November, what happened is that the Section 89 panel came with their report, and the Speaker of the National Assembly announced that the report of the independent panel would be released to the members of Parliament and the public through the announcement tablings and committee reports, which is sometimes referred to as the ATC. So if you hear people talking about ATC, they're talking about announcement tablings committee report. That panel, and I'm going to dive into, look out for this tomorrow morning, all of the stuff that has happened in terms of the different entities that have looked into the Phala Phala matter, the Section 89 independent panel, the public protector, as well as the South African Reserve Bank. Just looking at what they said, why they said, their legal arguments, and whether or not those legal arguments are necessarily persuasive, and just reflecting on the status of things. So look out for that. But the panel found that President Cyril Ramaphosa's conduct may have committed 4 violations of and misconduct relating to his office as the as state president. The Section 89 report made damning conclusions, right? It found that President Ramaphosa may have seriously violated the law and the Constitution. And we're going to have a discussion about that, as I said before, in detail, but that's what happened. On the 13th of December, 2022, the report was considered by the National Assembly at its plenary sitting. The ANC basically used its majority in Parliament to vote against the adoption of the report and therefore a subsequent impeachment investigation by this committee of Parliament. By the way, just because there's going to be an impeachment process doesn't mean that somebody's going to be impeached. It just means that a process is being set in place to properly examine with all the powers of Parliament, to subpoena, to inquire, to cross-examine, all of those powers to actually get to the bottom of what happened on the farm. How did money get stuffed in the sofa? Where did the money come from? Was the money compliant with tax regulation? Was the farm trading in foreign currency against all of the laws which speak to that, which I'll discuss in detail in a future video, which is coming tomorrow. So the ANC used its majority in Parliament to vote against this adoption, and there were some exceptions and notable absences. If you remember, on Wednesday, the 13th of December, 4 ANC members of Parliament voted against the party line, and they voted in favor of the report being adopted. So at the time, the Cooperative Governance and Traditional Affairs Minister, right, Nkosazana Dlamini Zuma, who had also been a presidential candidate at the ANC conference, or was going to be a presidential candidate at the ANC conference, actually voted for the report. She said, as a disciplined member of the ANC, I vote yes. This question of who is a disciplined member of the ANC, based on what decisions they make, is going to be quite interesting, because they're saying Zuma was ill-disciplined and they've kicked him out, etc. Nkosazana Dlamini said, I'm a disciplined member, I vote yes. Right? So Mervyn Dex, Msebenzi Zwane, and Supra Mahumapelo also voted in favor of the report. Then there were some absences. Tourism Minister, at the time, Tourism Minister Lindiwe Sisulu, she was absent. The presidential hopeful at the time, Zweli Mkhize, also was absent, even though both of them had publicly criticized President Ramaphosa about the Phala Phala saga, right? And former Minister of State Security Bongani Bongo was also not present at that particular sitting of Parliament, right? So in terms of the parties and how they voted, the DA, the Economic Freedom Fighters, the Inkatha Freedom Party, Freedom Front Plus, the African Christian Democratic Party, the United Democratic Movement, the NFP, the PAC, all of these parties voted for the report to be adopted. So they were persuaded by the arguments that were made by the former Chief Justice and the analysis and presentation that was made, right? COPE, Aljama, ANC voted against it. The Good Party abstained from voting. In the end, the motion was defeated, 214 votes to 148 votes. So if you think about this, there are 400 voting members in Parliament. 214 is a narrow victory. As a percentage, it's a very narrow victory. Just think about it. It's about 53.5% is the number that it is. So when you win a vote by 53%, yes, it's a clear win. But when you think about the technicalities of the issue and the gravitas of the issues, the fact that this was won on party line does show how tight it was, and just does lead to questions about whether or not it was actually a rational and objective decision. So Mapisa-Nqakula believes that this sequence of events made her powerful enemies in powerful places. This is why I think she's saying, when I elected to convene a parliamentary inquiry into the Phala Phala matter, I made political enemies. When I made this choice, I did so without fear or favor and followed the rule of law. I opted for a public vote on matters concerning the sitting president, Mr. Cyril Ramaphosa. So I think she did follow rule of law. I think there was nothing that she could have done at the time to circumvent this without creating a different type of parliamentary crisis to the one that we saw under the Jacob Zuma administration. I think that the decision which really put her in the crosshairs was not the decision to do the actual process of Section 89. I actually think it was the decision to remove Professor Richard Calland. I think her reasoning was correct, but it was probably unpopular in the Ramaphosa camp. Now, as I said earlier, Professor Richard Calland is a professor of public law at the University of Cape Town. He is, however, a self-professed Cyril Ramaphosa supporter, pun intended. And he's a supporter, by the way, also of renewable energy transition, which we know that has been popular in certain circles and questioned in other circles because of who stood to benefit, right? And if you look at how Professor Calland participated in the discourse after the his removal from the panel, you can see how he was going to move in the panel. You can really ascertain to a degree of certainty that he was going to be pushing back against any finding moving to the next stage. In one article that he wrote on the 2nd of December, he said, "A flawed report and dangerous precedents why President Cyril Ramaphosa should not resign." Few days later, just 6 days later, another article that he wrote, he said, "The day Cyril found his spine, in the face of the Phala Phala panel report, Ramaphosa has decided to stay on and fight to win." So you can see that he was going to be somebody who was not necessarily going to be objective and neutral, which is what you need. You can't have a perception of bias. You can't have a biased person. And if there's a reasonable apprehension of bias, that is enough to exclude someone from the panel. So I think it was the correct decision, but I don't think it was a popular decision. Now, what's interesting as well here to discuss, right, around Professor Richard Calland and his appointment, based on his positions that he published in the articles that I just shared with you, it seems he was appointed to the panel to try to influence it, to block the next step. He was very critical of the report after the fact, even though in 2017 he published a 10-page paper, 10 pages, with 37 footnotes. What is the paper about? It was a paper praising Chief Justice Sandile Ngcobo for ethical leadership, judicial leadership, and for his legal acumen. And by the way, people sometimes are very quick now to say, no, there were problems with the Phala Phala report. Minister Ronald Lamola said that. I saw Franny Rabkin, a legal reporter who does a lot of legal reporting for Sunday Times, repeat those talking points. But we must not forget who Chief Justice Sandile Ngcobo is, and even the rest of the panel that was in there. But let's look at former Chief Justice Sandile Ngcobo, who I'll just call Chief Justice moving on, but he's former, right? Former Chief Justice Sandile Ngcobo graduated from the University of Zululand with a B.Proc, which is a Bachelor of Law. And when he was doing that Bachelor of Law, he earned distinctions in constitutional law, mercantile law, and accounting in 1975. From 1983 to 1985, he studied for a LLB at the University of Natal in Durban. 1985, he completed an orientation course in the United States legal system given by the International Law Institute at the Georgetown Law Center in Washington. From 85 to 86, he attended Harvard. Harvard, not Harvard. Harvard. Which Harvard? Harvard Law School. That's the one that, what's his name? Mike Ross. Is it Mike Ross in Suits pretended to have gone to? Harvey Specter went to Harvard. So, former Chief Justice Sandile Ngcobo is at that level that actors pretend to be when they make legal movies. He went to Harvard Law School, where he studied for LLM. He concentrated on constitutional law, labor law, international legal process and international human rights. This is, you do see a constitutional law thread, even at Bachelor of Law, distinctions. Harvard, constitutional law. Come on, don't play with that. He is basically the Lionel Messi of law. Or he's up there. Maybe you have a different, but he's up there. You have a different name, but he's up there. Then he served as a judge. His judicial experience includes the following. He served as a judge in the KwaZulu-Natal Industrial Court in 1993, the Western Cape High Court between 1996 and 1999, the Labour Appeal Court between 1997 and 1999, the Amnesty Committee of the Truth and Reconciliation Committee, 1998 to 1999. He served as an acting judge president of the Labour Court and the Labour Appeal Court. So he's not somebody who just popped out of nowhere. Then he was appointed to the office of the Chief Justice in 1999 and served in that capacity from 1999 to 2011. 12 years. Not 12 years a slave. 12 years a Chief Justice. 12 years a Chief Justice. That should be the name of the book about him. So when somebody with that legal scholarship, legal acumen, and who comes vouched for by professors of public law as being exemplary in judicial leadership, says you have a prima facie case against you, that is not a joke. That is a serious thing. And by the way, right, the court said, in light of all of the information placed before the panel, we conclude that this information discloses prima facie that the president may have committed a serious violation of 96(2)(a) of the Constitution, a serious violation of Section 34.1 of the Prevention of Corrupt Activities Act, a serious misconduct, and that the president violated Section 96(2)(b) of the Constitution by acting in a way that is inconsistent with his office, a serious misconduct in that the president violated Section 96(2)(b) by exposing himself to a situation involving a conflict between his official responsibilities and his private business. These are not trivial findings, even though they are prima facie, meaning we think it's serious. We think the story that has been given by Hazim Mustafa and the president is not adding up. Parliament, look into it further. Look into it further. This is being said by somebody who studied constitutional law, even while he was doing his BProc in 1975, finished in 1986 as a student with a master's from Harvard, not Harvard, Harvard. Not just doing a Mickey Mouse course. There's a rapper. What's the name of this rapper who just did a certificate course at Harvard? You know, they've got courses where you don't have to qualify to enter, etc. Harvard Law School is one of the most difficult law schools to get into in the world. This guy got in and got out. This is not a trivial legal mind, scholar, person, entity. This is one of the most, what is the word? I've run out of words. He's one of the most distinguished, but that's not the word I was looking for. There's a word, man. You know when you've won Pulitzer Awards and Nobel Awards and like Emmy something. The word is gone, man. The word is not with me, but you get what I'm trying to say. You get what I'm trying to say. So this is where things are. And she said, because of this decision which precipitated this, I'm in this particular position. Now let's talk about Mapisa-Nqakula a little bit and what else she said, because she made some other interesting point. You need to know that she's currently charged with 12 counts of corruption and 1 count of money laundering. Hey, this thing of money laundering, it will catch you one side. Other people yaba punyuga, other people yaba poop. You know, there was once a guy who was caught by the police going across the border with a bag of money. They arrested him. Same time, they didn't play games. They're like, when I said Bopa. But anyway, Mapisa is charged with 12 counts of corruption, 1 of money laundering, right? And this is a matter before the Pretoria court. The charges relate to her time as defense minister when she allegedly solicited and received kickbacks amounting to 4.5 million rand from a defense contractor. The contractor in question is Nombasa Ndlovu, whose company, Umkhombe Marine, was a service provider to the department. In her recently filed court application, Mapisa-Nqakula actually is saying she wants access to sections A, B, and C of the police docket. Apparently, she doesn't have the full docket. The state has already has disclosed section A of the docket. Section A contains the charge sheet and the indictment, but the state is refusing to hand over the other sections, which deal with correspondence, which is section B, and the investigation diary, which is section C. So what happened was Untondwa Ndlovu, who was initially being investigated by the military for corruption before her matter was suddenly abandoned, she then became a state witness against Mapisa-Nqakula. And Mapisa-Nqakula is saying, look, can I see that military police docket against Ntsondwa Ndlovu and all the related material to her case? She's also requesting to see the informer dockets from the state. She's saying that she believes that the state is prosecuting her on highly suspicious and tenuous evidence, and her legal team and herself need to have access to the evidence that they're relying upon. What she said is, I accordingly request that this court intervene and restore the balance by equalizing the obvious asymmetry of information caused by the clear obfuscation of the process by which the state has gathered or indeed manufactured evidence against me. This is in her court affidavit. She repeatedly claimed in that actual application that she's being prosecuted by a trial through the media. She said many details of her case were leaked to the media prior to her legal team being aware of them. The media seemed to be better informed than anyone in this matter, she said. She said that she learned through the media that Ntsondwa Ndlovu and her husband, who's now suspended, who was the Deputy Surgeon General of the South African National Defence Force, Major General Noel Ndlovu, were being investigated for a tender worth 210 million. She learned that through the media. She also says that the state made disclosures to the media. She says the decision to make disclosures to the press and the availability of the second statement are issues which will more than likely have been dealt with in the B and C sections of the docket. The facts and circumstances of this decision are vital to the court when it seeks to make a rational, reasonable, and informed decision as to the credibility of the investigation, the credibility of the state witnesses, and whether the incumbent prosecutor, Advocate Bheki Manyathi, can prosecute in this matter, more especially because he's also a witness in some or all of these issues. These are actually some key things that she's raising here. Look, you need to have access to exculpatory and incriminatory evidence when you are an accused. The state needs to tell you this is the evidence we have against you. They also have to tell you this is the evidence we have in our possession, which seems to indicate that you may not have done it or whatever. They can't just give you one set of evidence, but it seems here they've given her nothing. They've given her nothing. And remember, on the 19th of March, right, her Johannesburg home was raided by the NPA's investigative directorate. And she said that after that investigation, the media had the state brief before she and her legal team were able to challenge even the legality of the raid. She said that, like a wig was taken at random, documents were seized but not disclosed to a legal team, and audio recordings of the proceedings have not been released yet. So what she's saying is that her material argument is that there has not been full disclosure to her side. The state, on the other hand, has said that they're opposing this affidavit. Their opposing affidavit was provided by the Assistant Director, Abraham Pinang, who is an investigator for the NPA's investigative directorate. In the affidavit, Binang said the state would not be dragged into the political battle with Mapisa-Nqakula and will only respond to issues of law. He said the state is not aware of any informer dockets related to Ntsondwa Ndlovu's docket with the military police. He said the state was opposing the releasing of the investigation diary and correspondence of the investigating officers. This is section B and C of the document. He said, They are privileged, confidential, and have no relevance to the application's fair trial rights. This is what Binang said in the court affidavit. They don't constitute exculpatory evidence in favor of the applicant and are also not incriminating against her. They will therefore not be used at trial. So the trial is basically going to rely on the witness testimony, I guess, if they're not going to use these documents. But I find that to be very peculiar. And in the normal course of affairs, you need to get all of these documents, to be quite honest with you. This is a very peculiar situation. I find the argument that has been made by Mapisa-Nqakula that the media seems to have more information than her to be true. The media has these files. They have all the details. The media was the one telling us about wigs, telling us about evidence that the state is going to be relying on. We read this in the news, and if she was reading it same time as us, instead of her lawyers being able to tell her, this is what they've got, this is what they're saying, something will have happened that's not right. And we've seen how the media sometimes can be weaponized, and it even ends up going into some of the judgments where judges will now start referring to media reports. This book, this one, you see this book, please procure this book. We are going to look at it in the book club as well. Manufacturing Consent. Manufacturing Consent. This book discusses how the media, mainstream dominant media, is weaponized often to get rid of people who are problems or even to retaliate against people. I don't know if Mapisa is telling us the full truth, but from the timeline, we can see that she was in the good graces until a certain moment in history. And then boom, charged. Charged. Is she right that it's because of her decisions to get the Section 89 panel going? Or is she just trying to find a political way out? What do you think? Let's have a conversation. Tomorrow is a big day, and I'm going to have a big episode in the morning around the previous judgments and all of that. Not judgments, findings, determinations by different bodies that have looked into the Phala Phala matter as this issue goes to the Constitutional Court. Has the media covered this enough in your opinion? What do you think? Let's talk about it in the comments. I'm going to be there. And remember, the SMWX Mkhonto thing was a joke, guys. It was just a joke because everyone was going to SMWX to say that they're joining MK. So I thought, you know what, let's just troll a little bit and also let me join because everyone comes here to join. But I didn't join. I'm not a member. I think it's important to have voices in independent media doing research, analysis, commentary. We can't lose those voices into political formations. We need those voices on the streets. Till the next one, guys.